Hi, my name is Bella. I'm excited to welcome you to tonight's constitutional conversation on presidential emergency powers. We are delighted to welcome Philip Zelikow. He is the Botha Chan Senior Fellow at Stanford University's Hoover Institution. For 25 years, he held a chaired professorship in history at the University of Virginia, where he also directed the nation's leading research center on the American presidency. For 7 years before that, he was an associate professor at Harvard University. In his scholarship, Zelikow focuses on critical episodes in world history and the challenges of policy design and statecraft. An attorney and former career diplomat, Zelikow's federal service includes work across the government in the 5 administrations from Reagan through Obama. On the NSC staff, he took part in the diplomacy to unify Germany and end the Cold War. As counselor of the Department of State, he had deputy-level policy responsibilities on issues around the world. He is one of the few Americans to have served on the President's Intelligence Advisory Board for presidents from both political parties. Zelikow has also directed 3 successful and bipartisan national commissions: the Carter-Ford Commission on Federal Election Reform, the 9/11 Commission, and the COVID Crisis Group. Please join me in welcoming him.
Thanks. How many of you, if you're a law student, could you raise your hand? I just want to see how many students we've got here. How many students out of the vast student body had the discernment and good judgment to attend this talk today? Excellent. So I'm talking today about presidential emergency powers. My interest in emergency powers and the problem of how democracies handle emergencies goes back a very long way. Once upon a time, more than 40 years ago, I was a trial and appellate lawyer in Texas, in Houston, where I specialized in criminal and civil rights work at both federal and state level. And one of the first cases I was involved in that got national attention was when I was the counsel for a group of Vietnamese shrimpers on the Texas Gulf Coast who were being attacked by newly organized right-wing militia that called itself the Knights of the Ku Klux Klan, that had set up paramilitary training camps in the Texas countryside and actually had been organizing assaults and harassment of these Vietnamese refugees who had settled on the Texas Gulf Coast. And so I joined forces with an outfit called the Southern Poverty Law Center in Alabama, and we brought suit against the Klan to shut down these paramilitary training camps, invoking an ancient Texas law from the 1880s that banned private military organizations. Of course, they were training with long guns and all the rest of it. And actually, that lawsuit was successful, and it shut them down. And actually, the Southern Poverty Law Center, we actually developed the definition of private military organizations that was adopted by the court, which we then took and went after the Klan in another case in North Carolina that was also successful. This was actually in the early days of the New Right nationalists, the New Right militias. This is the early 1980s. These are the folks who later would, in a further mutation, blow up the federal building in Oklahoma City in 1995, and then subside for a while and have reemerged in recent years in some different forms. But that was a long time ago, 44 years ago. But ever since then, I retained a keen interest in internal unrest and terrorism and how democracies cope with extreme problems. I carried that into a lot of my government work. I've worked on legal issues involving terrorism and emergencies in many sorts of situations over a period of about 40 years, including directing the 9/11 Commission. So presidential emergency powers are very much in the news now. And I actually have been involved in them most recently and taking a very active part in the tariff litigation. Because I'm interested in trade law and economics too. And so I thought I would launch into that and review some of the emergency power issues at work in that case, where the lead, I just filed along with Alan Sykes as an amicus in a brief last week, and then I've also been working closely with the counsel of record for one of the lead plaintiffs in the case, VOS Enterprises, who is another Stanford Law alum and the head of the center, Michael McConnell. And McConnell's brief, on behalf, which is one of the main briefs, was filed 2 days ago. And it's a very good brief, by the way. McConnell deserves a lot of credit for that. So I want to go over the case, help illuminate the issue of emergency powers there, but I want to segue from that actually into some other issues involving emergency powers that may be even more controversial. All right. So rather than make this a tale of two cities, I'm going to make this a tale of two powers, a tale of two traditions, and a tale of two paradigms. So the two powers I want to introduce to you are the powers of Congress over trade and the power of the president over war. The first set are enumerated in Article 1 of the Constitution. And interestingly, the powers of the Congress over trade are twofold. You hear a lot about the fact, and all of you I'm sure know, that Congress has the power over tariffs, which goes along with the exclusive power Congress has in the Constitution to levy taxes. Back at the time of the founding, actually, tariffs were the principal means by which the federal government raised tax revenue. And for at least half of the country's history, tariffs were seen as primarily an issue of domestic politics. But that's actually only the first of two powers that Congress gets in Article 1. Tariff power, tax power, you got that. The second power is that Congress is given the power in Article 1 to regulate commerce with foreign nations. So right off the bat, you know that, well, I guess that regulate commerce with foreign nations has something to do with foreign affairs. So yes, the founders gave Congress that particular foreign affairs power. The other power has to do with war. Now, there is not an article that says the president has the power over war. In fact, Article 1 gives Congress the power to both to declare war and to raise armies and militias. Article 2, however, says that the president shall be commander-in-chief. And over time, that's generally been taken to include a variety of responsibilities the president has for national defense. So we've got a paradigm of two powers: Congress over trade, and the president, to some degree, over war. Now, those two powers actually then flow into two quite distinct traditions. The first tradition, which spans more than 200 years, is the tradition of how we go about regulating commerce with foreign nations and handling tariffs. This is actually a fairly elaborate tradition, and it's worth noting this because in the fairly narrow dispute simply over tariff power, you can miss the fact that Congress has actually set up a whole legal tradition of how to handle trade. And the argument in the last year is not only over the usurpation of the tariff power, it is also actually the usurpation of the entire structure that Congress has established over many laws for how to handle trade. So in this first tradition, a couple of milestones. So trade. Say for the first 100 years of the Republic, basically we had tariffs unless we had some special trade treaty with you. So we had basically a tariff system, a tax system, on everything coming in. Then with some countries that we liked, we might sign a special treaty of commerce and navigation. And we might have some special trade arrangements with that country. Say the first of those was signed with France. And then later on, we even signed one with Britain after some troubles. And then there were several other countries over the course of 100 years. And the big milestone that occurred in the 1800s, the Europeans had developed this practice, since a number of them had trade treaties with each other, which had this rate in that treaty and that rate in another treaty. And they basically said, you know what? If we have a trade treaty with you that is like, you're on good terms with us, we're going to give all the countries with whom we have trade treaties about the same rate. And then the countries with whom we don't have trade treaties, well, they're out in the netherworld. And this was called, in the 1800s, most favored nation status, because there were only a few favored nations, but you got that status. And the United States, this starts getting going in Europe in the 1860s. The United States looks at it warily, not sure it wants that sort of thing. Finally, there's a key phase, really from (1919 to 1923), when after a bipartisan tariff commission report and much discussion, the United States says, we too will adopt the approach of most favored nation approaches, which means if I have a trade treaty with France that says French wine comes in at 10%, well, I have another trade treaty with Spain. They also sell me wine. I'm going to say, you know what, Spain, I did this 10% wine deal with France. If I do that for France, you, Spain, as another country with whom I have good trade relations, you get 10% on your wine too, without my having to write another special treaty with you. Because this patchwork had just gotten too Byzantine and complicated for what people thought of as the modern America of 1919. And by the way, this change occurs and is implemented in the Harding administration, which is a pro-tariff administration. Adopts a big set of tariffs called the Fordney-McCumber tariffs in 1922, but issues the instruction in 1923 that from now on we're going to adopt this modern most favored nation approach, so that if we give states that have special trade relations with us a particular set of rates, automatically, unconditionally, without discrimination, other nations with whom we have these good trade relations get those rates too. Unconditional, non-discriminatory, those are the kinds of words people use. And indeed, all subsequent acts passed by Congress on trade more or less conform to this standard. There will end up being a few wrinkles here and there for things like special preferences for poor countries, or certain kinds of free trade agreements, and a couple other things. But by and large, that's the standard. In 1998, we changed the terminology. We said, we're not going to call most favored nation is a quaint phrase. We're just going to call countries like that countries with whom we have normal trade relations. And by the beginning of this year, we had normal trade relations with all but 4 countries in the whole wide world. All but 4. You could argue that today we have normal trade relations with 0. Since that entire system, that entire approach, the unconditional, non-discriminatory way of regulating commerce with foreign nations, has actually been junked by the presidential decrees. You'll notice this is irrespective of what you do with tariffs per se. My critique has to do partly with Congress's Article 1 power to basically set the way we regulate commerce with foreign nations, and to notice the president has overthrown that. But then there was a period, then there is some important stuff to do with tariffs. After the landmark tariffs, Fordney-McCumber in 1922 and infamous Smoot-Hawley of 1930, and then Great Depression, there was a sense of, well, let's liberalize trade and do better. And starting in 1934, kind of a high tide period of Congress delegating wide authority to the president to negotiate trade deals and lower tariffs by proclamation, ran from 1934 to 1974. And after World War II, we created the General Agreement on Tariffs and Trade. We did other things. There's an important Trade Expansion Act in 1962. By the late 1970s, it was clear that more and more of the problems were moving out of the area of setting tariffs and were more into problems of non-tariff barriers to trade. Really from 1974 to date, we've had a different system in which the president usually is seeking authority to both negotiate reductions in tariffs and also the elimination of non-tariff barriers. And usually, therefore, he asks to go in advance to get the authority from Congress on both the front end of that, to get what's called fast-track authority to negotiate these tariff, non-tariff barrier deals. And then, having concluded such a deal, he had to go back to Congress to get it to approve that deal on the back end. And we've done such deals on multilateral bases and other bases with a number of countries, supplemented by now the rise in the 1980s of free trade areas, where you would actually bring tariff rates for some countries, including work on non-tariff barriers all the way down to zero. So I just wanted you to get a sense of this whole legal tradition and so many acts of Congress, of course, under that legal tradition. By the way, the last time a president had the authority to negotiate a trade agreement was granted by Congress in 2015, and that authority expired in 2021. So no president has had authority to negotiate a broad trade agreement with another country since July 1st, 2021. So, but this president is not does not want to feel so confined. So you've kind of got this general picture here of one legal tradition. So then there's a parallel legal tradition of how to handle wars and emergencies. It turns out that during wars, you do still need to regulate commerce in wartime in various ways. You need to figure out how to handle property belonging to enemy citizens that's in your territory. You need to handle certain peculiar things where maybe there are third-party transfers or transactions that involve enemy property or enemy goods. In some cases, maybe even the odd good that the government wants to allow to be traded somehow because it kind of needs it. And there's a long tradition then of embargoes and other sanctions. This is also the tradition of sanctions. This is basically a whole tradition, legal tradition, of how do we deal with our enemies. This first tradition is mainly about friends. Other tradition to do with enemies. Different traditions. Okay. And mostly this is a series of episodes, but there's a big codification of how to handle trading with the enemy in something called, hey, you guessed it, the Trading with the Enemy Act, which the cognoscenti just call TWIA. See, you're going to come out of this lecture slinging acronyms around like a trade expert. There's TWIA. So TWIA lasts from 1917, well, really to 1977. You can make an argument TWIA still operates if we had a situation of declared war or active hostilities with a country. And so there is some residual TWIA stuff that would apply if we were in a real shooting war with somebody. But for our purposes, let's just say runs this. And then, and TWIA had some language in it that said, you know, you can regulate a whole kinds of things involving these countries in in wartime. And one of the things there's a long list of terms, and one of the things it says is regulate importation, as in like embargoes, or you can regulate importation. And in this context, everyone always understood this to mean regulate means mainly I start or stop. Like I don't let stuff in. No one thought it like meant tax, that regulation means tax. So, and then in 1977, some key language in TWIA was reenacted in an explicit emergency statute called the International Economic Emergency Powers Act, or IEPA, again, as one of the cognoscenti. That was actually regarded as somewhat narrowing and more procedurally reenacting the old Trading with the Enemy Act to kind of confine and narrow some of the terms. Is everybody with me so far? You got these two traditions. So the whole tariff powers case hinges on an anomaly, and it is this. In the dark days of the late summer of 1971, America worried about its balance of payments deficits. There was a drain of gold under the old Bretton Woods system. Something had to give. The president secretly huddled his advisors together at Camp David. Not a word leaked out of what they were discussing. And then, lo and behold, we overthrow the Bretton Woods system. We close the gold window. We go to floating dollar. And this is a revolution economically. Well, when all that was getting done at Camp David, we're going to go to a floating dollar overnight. In a situation where there's some unease about the value of the dollar, there could be a run on the dollar and a sudden depreciation. So folks said, when we issue these orders, maybe what we should do is have a temporary surcharge on imports just to slow down dollar depreciation and make sure there's not a run. Like a 10% surcharge on all imports that will just be temporary, just to be sure there's not a run on the dollar. And so actually, you could say, sounds like, and actually the executive order that had that surcharge in it said this is a national emergency. So a lot of people think that that means Nixon used emergency powers to do a tariff. You see? So I tracked down the lawyer who wrote the Nixon EO in 1971. He's still around, sharp as a tack. Back then, he was 29 years old. His name is Alan Wolf. He was a Treasury lawyer. Because he was working at the Treasury Department, he was in the loop for all the secret stuff. And I said, Wolf, what were you doing here? He says, Wolf explained, well, we didn't actually use emergency powers law. When we wrote the Nixon executive order, we actually relied on extant trade law. You see, there was a provision in trade law that the president could proclaim these lower tariffs, but that the president, if he got pissed off about something, he could rescind, he could terminate these tariff proclamations. That was in the trade law. And so we just said we'd use our termination power in the trade law. We didn't actually say we were going to use we weren't going to use like TWIA. Who used TWIA? And so they write that in 1971. The executive order only cites the trade law. They get the guy from the Office of Legal Counsel, a hot young lawyer at the Justice Department named William Rehnquist. He comes over, he reads this, yeah, good to go. And so they put out this executive order, which does not cite TWIA. Come December 1971, surcharge is indeed temporary, it goes away, and everyone's living happily ever after. Except there were people who complained this surcharge was illegal and they wanted money back from the federal government, so they filed suit for claims. Litigation ensues. Years later, in 1974, in the what was then called the Customs Court, the claimants come in and the government says, well, we had this termination authority in trade law. The judge hoots at this. It's not. And then desperate lawyers, nameless lawyers in the Justice Department, said, how do we avoid paying these claims? Well, let's just tell them we can justify it with TWIA. So remember, in 71, they didn't use TWIA to justify the executive order. Here, years later, long after the surcharge is gone, in the litigation over claims, lawyers come in and say, well, let's try out TWIA as a legal argument. Well, the Customs Court hears that and says, that's a terrible argument too, and pours them out. They lose. But then the desperate Justice Department appeals this, and in 1975, the appellate court that covers this, which back then was called the Court of Customs and Patent Appeals, a circuit court that's now just called the Federal Circuit, not always made up of our most distinguished jurists. Anyway, the Court of Customs and Patent Appeals looks at this as, well, we don't like that termination argument, but we don't want to make the government pay these claims, and we're going to kind of give them a one-time pass with this TWIA story. This is a CCPA decision of, I think, November 1975. The entire government case in the tariff powers case now turns on that precedent from November 1975. That is their whole argument. It is the only precedent they have for why an emergency powers law could justify a tariff, other than the assertion that regulate importation can mean that, even though no one before or after ever thought it did. So, by the way, in that court case, you go through it, and you can just tell that the judges were so uneasy about doing this. There's like 6 different ways they say, do not take this as a precedent to ever do this again. No president should ever think they've got a power to set a tariff because of this decision today. And Congress actually, by the way, in 1974, Congress noticing what had happened in 1971, in the Landmark Trade Act of 1974, where they set up fast track authority and stuff, they actually passed the authority to handle a temporary import surcharge. If a president thought he needed it, they said it can only be up to this much and it can only last for this long for a balance of payments problem. That was in Section 122 of the Trade Act of 1974. So no one actually is taking much notice of these court decisions until 2025. And now we come to the Supreme Court, and we're making these arguments that these traditions were never supposed to be flipped, because this entire body of law is being overridden by President Trump's use of this body of law. And actually all relying on that one anomaly. So, any questions so far? Just about the facts just on the facts. No need any. We'll hold comments for later, because I'm going to shift gears a little bit. Okay, yes?
Is there meaningful difference in the language in 1971 or the relying on TWIA? Is there meaningful difference between the language in IEPA, which the president is relying on now, and the language that was relied on by the Federal Circuit?
In this particular clause, no. See, because what happened was, remember that when the Trade Act of 1974 was written and stuff, nobody thought that there was any basis for this. Even the lower custom, if anyone had paid attention to the Customs Court case on claims, which mostly they didn't, the government had been poured out in the Customs Court. So they write the Trade Act of 1974 that solves the original 1971 question of authority, kind of nailing that down tight. And so they reenact basically that same language with no one thinking they've done anything important, and hardly anyone taking any notice of that silly Court of Customs and Patent Appeals case, right, until 50 years later. So to me, therefore, as you can tell, I actually think the tariff powers case is relatively straightforward. And I think I've read all the briefs. I've been in this case as an amicus since the district court level, and then through the circuit court and now in the Supreme Court briefs. I've been reading briefs on this and participating in moot courts with our lawyer who's going to argue this, and I'll participate in another moot court on this next week with Neil Katyal, who's going to be arguing this on November 5th. But I think this is straightforward. Now, that doesn't mean the court's going to do what I think is straightforward, but from a legal point of view, I don't think this is like a super hard case, really. But I wanted to just, but incidentally, the clarification, the way I presented this to you, the lawyers in this case, including me, did not see it quite this clearly 5 or 6 months ago. To be fair, this is actually one of the nice things about legal work, is sometimes you work hard on stuff and you actually get smarter and your thinking improves and gets clearer. And I think if you were to compare the briefs we've just filed with the briefs, say, we filed 4 or 5 months ago, they're like way better, in my view. But I think as the court goes, if the court goes through those briefs pretty conscientiously, I feel pretty good about where we are in the case. So what I want to do in closing is I actually want to introduce what I regard as a more controversial problem. I want to introduce this problem of 2 paradigms. I want to switch gears from the trade paradigm to the contrast between law enforcement and war. Now I'm really switching gears. But because the general topic is presidential emergency powers, I didn't want to just stick, in a way, to the fish in the barrel. I wanted to take on some stuff that's a little harder, and which is very much in other litigation right now. So I want to tell us a little bit of a story. It's like paradigm law enforcement. Because I've lived this story in a lot of my professional life. Long ago, back in the 1980s and into the 1990s, we treated terrorism as a law enforcement problem. It's, the young people here may have trouble struggling to remember such a time, but yes, there was such a time. And so when terrorists did bad things overseas, with extremely specific minor exceptions, we mainly tried to get police, or maybe sometimes helped by CIA, to go chase them. So in 1998, when Osama bin Laden's group, which later would become famous as Al-Qaeda, blew up 2 American embassies in East Africa, we indicted him in federal court, by golly. And FBI agents deeply investigated that case. And then when Al-Qaeda blew up an American destroyer in Yemen in October of 2000, almost sinking it and killing a number of sailors, the FBI agents were out in Sana'a investigating that crime. And the Clinton administration, actually in 1998, they had fired some cruise missiles at supposed hideouts in Afghanistan and did not much more than that. And in October 2000, they didn't even do that. And the incoming Bush administration wasn't sure what to do either. They were in this law enforcement paradigm. Well, they were killing Americans, but it wasn't that many Americans. And, you know, we do CIA hijinks and other things, which is a story I know pretty well. In one of my jobs, I was actually the member of the Deputies Committee on the State Department for all intelligence and counterterrorism issues around the world. And I've sat in on, later on in my career, would sit in on meetings where decisions would be made about whether to do targeted killings. So I have like hands-on experience with this stuff. But we were in a law enforcement paradigm because terrorism, we weren't at war with terrorists. Now, Al-Qaeda had declared war on us, actually in writing, in January 1998, in a fax they sent from Afghanistan to London that people kind of smiled at. Well, and then comes 9/11, and you know what? We decided we were at war. And we did not ask Afghanistan anymore for law enforcement assistance in figuring out what to do about Al-Qaeda. And we went to Congress and asked Congress to say that we were now at war. And Congress said, effectively said, yes, we are, and passed an authorization for the use of military force and meant that we should use it. So, but I just want to give you this history of how we struggled with these differences in paradigms. We now take for granted that in a case like Al-Qaeda and a serious transnational terrorist group, that's a war paradigm. And then we can argue about war powers and law of war issues, and I've been deeply involved in some of those arguments. I was notorious, in fact, on some of them because I was very much involved in the big public controversies over torture and all of that in the mid-2000s, both secretly and then publicly. But we have this tension now again right now. So for example, the Trump administration this year is saying that we are now at war with narco-terrorists, that these drug traffickers are like terrorist groups, and we're at war with them too, and that we're doing these military actions. Incidentally, Congress only passed that formal authorization for the use of military force after 9/11. So the little lash outs we did, like cruise missiles in August of 1998, actually were not accompanied by a prior congressional authorization. It just seemed like too discrete an episode. There are analogies. There's an interesting case. I was in the White House in 1989, and so I'm very familiar with the invasion of Panama. The Panama thing is not a perfect analogy to Venezuela for reasons we can get into if folks are really interested. The Venezuela case is legally much harder than Panama, I'll just say. But the fundamental conceptual issue is interesting. And I follow the commentary on this, and maybe I had all of you on my side when I was complaining about how bad the president was on trade and tariff powers. And now maybe I'll lose a lot of you by saying that you've got to pause for a moment on this problem of the narcotics cartels. I'm not saying the administration is right, but I'm saying this is actually a hard problem. This has actually been a hard problem for a long time. When the UN Charter was written that talked about armed attack in 1945, they weren't envisioning large-scale, extremely well-armed, organized cartels carrying out transnational crime on an epic scale in countries that were either incapable or tolerant or actively colluding with those activities, that many of which were meant to end up with crime and violent crime inside the United States on a very large scale. Now, there you can hearken back to precedents from the age of piracy, and when actually back in the day, governments had very little patience with countries that harbored pirates. And, but we have much more stuff now in law, both domestic and international, than we did back then. But I want to present the novelty of the problem. The president and the administration are asserting what these people are doing is a kind of war on the United States. And this raises issues of both US and international law, and they're both difficult in my view, although the international lawyers don't find this difficult at all, I'll just tell you. But then again, they didn't find the terrorism stuff all that difficult either until 9/11. So you've got these cartels, some of which actually do work with governments, either tolerated or in active collusion with to certain degrees, usually alliances of convenience for solving problems of mutual interest, which is one of the reasons the leader of Venezuela is currently under federal indictment. So, as the leader of Panama was, by the way, before he was arrested after the United States invaded Panama, and by the way, ended up in the Atlanta Federal Penitentiary for a long time, the rest of his life, in fact. So, I just wanted to raise this issue. Now, in my own view, the question of whether or not the operations of these criminal cartels should be considered warlike, should be considered as an attack on the United States, is to me a political question, and one that ought to be decided by the American people and their representatives. It is a question capable of multiple views. But it is a big damn deal, and especially in a country like Mexico, which is an enormous problem. So then there is a question of at what point should the president ask, should the president decide, should Congress decide whether or not, and make an affirmative decision one way or another. There is simply no doubt, by the way, that should Congress simply get up and say, pass a resolution and say, this is not war, that would pretty much end the story as far as any claim of U.S. legal authority would be concerned. But the current Congress, there is no inclination in the current Congress to say that. And certainly not on the designation of the certain criminal cartels as foreign terrorist organizations. By the way, which they are doing under federal law passed by Congress. The law that allows for a designation of a foreign terrorist organization is codified in statute, and the president's executive orders are acting inside that statute. And there are definitions in that statute that they are interpreting to at the outside of the envelope. And this, of course, again, leaves aside the question of international law. And that's kind of where I wanted to leave my introductory talk today. Because really, all emergency powers are basically meant to carry forward the kinds of powers we need in war in situations where we do not have a formal declaration of war. And in a way, we haven't had a formal declaration of war since December 9th and December 11th, 1941. We've had other kinds of things, including things that have been done by Congress. But we're increasingly in a difficult space as to how to define formal war. And so I wanted to flag that issue because that also is a facet of emergency powers. And I think a problematic and more controversial one. I may think that the president has gone too far in saying that we're at war with these folks without asking Congress to agree. But, so even if I think the president is wrong in not doing that, I will step back and say the problem of what to do about these cartels is presenting a novel and really challenging problem for American policy that reminds me of some of the problems we had with terrorism in the 80s and 90s. And just saying, well, that's law enforcement, call it a day, and whatever the weaknesses of law enforcement are in, say, like Mexico and Venezuela and even in Colombia now under Gustavo Petro, I think that those are interesting questions and are very difficult questions. And I'll stop there and throw the floor open to you.
If you have questions, please line up at the 2 microphones.
Hello?
Yes, hi.
You alluded to this really briefly, and I'd love to hear your thoughts about a situation this country has faced and continues to face when you have someone, an alleged terrorist, who's an American citizen in a foreign country, and the government has decided that this person is a terrorist, that they pose a threat to US troops or national security. They don't have a gun or a rocket launcher in their hands, but we have a drone above them and we decide to kill them. Can you talk about the legal construct for that decision-making process, and if you think there are any flaws or challenges with it?
Sure. Incidentally, it's not unusual for American citizens to take up arms in an enemy army and be killed by our soldiers. Actually, a number of people in the Wehrmacht were American citizens. Not a large fraction, but there were numbers. Indeed, when the Germans landed saboteurs in the United States during the war, a few of them were actually also had dual citizenship, had American citizenship. They were electrocuted just the same. But so that problem would come up from time to time. But the very concrete question you asked actually has come up. The famous case that I'm very familiar with is the case of a man named Anwar al-Awlaki, who is an important figure in the 9/11 story as well, and was a suspect as a part of a support network for the hijackers in the 9/11 attacks, both in the San Diego area and then later in the Falls Church, Virginia area, as a spiritual guide to the hijackers, whom the FBI decided they couldn't make a case against him to arrest him as complicit. He eventually left the country and then became openly helping al-Qaeda back in the Arabian Peninsula and publishing lots of stuff and making videos encouraging people to kill Americans. And eventually American forces hunted him down, tracked down where he was, and launched a targeted strike that killed him and one of his children. So what happens in a case like that is basically, this is a person who had openly joined the enemy camp, was openly a member of an organization that was at war with the United States, and was openly at war with the United States. And so then it's really, from the point of view of deliberating what to do, it becomes a law of war question. You can have an argument that says, well, if an American citizen is in the enemy camp, joining with the enemy, are there special due process rights and so forth that inhibit the normal operations of the law of war? And in that particular case, our government ultimately concluded that the law of war applied. And he could properly be judged to be an enemy combatant. By the way, one of the misleading terms you'll sometimes hear is between, like for instance, the administration right now uses terms like unlawful enemy combatants to describe the people that are there killing in these drug boats. This is actually a confusing and misleading adjective. It's as if, gee, if you're an enemy combatant against the United States, somehow that's unlawful. It's not against the law to be an enemy of the United States. It's not against the law to be at war with us. It just means that if you're at war with us, we're entitled to kill you if you are an enemy combatant.
But there are rules around how we kill people.
That's correct. And so, but if you're an enemy combatant in the field and we can find and identify you, we can target you, and we do. And then there are law of war issues having to do with proportionality, collateral damage, things like that. And you get into and people who are deliberating over those decisions go through all of that. But that's the process that was adopted in that case and would, I think, probably be adopted in any such future case, no matter who's in. Incidentally, al-Awlaki that targeted killing occurred, if my memory is right, during the Obama administration, and was handled by their lawyers. But the lawyers did look at it, and they did have the argument that I just kind of summarized for you, but that's the way they came down on it. I think actually that particular strike was not carried out by the CIA. It was carried out by overt armed forces of the United States. Yes.
Thank you, this was great. Here, I can just speak. I'm curious if you could reflect on the relationship between political polarization and challenging presidential assertions of emergency authority. I think for political and cultural reasons, we would want Congress to stand up, but in our current moment, in periods of unified political control, and certainly with this Congress and the president, Congress isn't enforcing institutional prerogatives and is just going along with party lines. So reflect on that, and then also you were in public service for a long time in different periods, so if you could comment on your whole career on this, I'd be grateful. Thank you.
Well, yeah, this is a very polarized period, and Congress is reflecting that polarization. And you can see the way the polarization is affecting these debates. It is true that the majorities in both houses of Congress are currently towing the line for what the president wants. They were democratically elected, and it's their prerogative to decide to do that, and they are. We might wish that more Republicans would dissent on this or that issue, but that's kind of where things are. For instance, on but I'm not 100% sure that if the president did not have such an iron coercive grip, that actually a lot more Republicans would defect, say on the issue of whether to designate these cartels as foreign terrorist organizations. What they're tending to do is say, can we have more information, please? Can you please show us the basis on which you're reaching these determinations? Can you share more with us? They're not, and I notice politically, they are not choosing to go right at the main point, saying you are wrong to say we're at war with these groups. They're not quite saying that. And I think that reflects a sense that they're not sure that the majority of American people will be with them if they confront the president directly on that value choice. And maybe the American people in that sense and the Congress is wrong about that, but that's some of the politics of this. But let me give you another example of the polarization. This is playing out this week right now. For instance, in the deployment of federal troops in Portland or the deployment of federal troops in Chicago, which is gonna, there'll probably be further decisions on this in the next few days, maybe even in one case later today. So, for instance, what's happening right now is, on the Democratic side, the proposed deployment in Portland is out of the question and unacceptable. He says Portland is war-ravaged, and that's a ludicrous statement. And then he wants to deploy troops in Chicago. We say that's also ridiculous and out of the question. If you read the opinions in the litigation and the briefs, the facts of the cases are somewhat different. And the facts of the case in Los Angeles were also different. What they proposed in Portland is to call up 200 members of the Oregon National Guard to protect the ICE building in Portland. The ICE building in Portland had to close this summer for 3 weeks because they could not do their work because of the protests. And when you go through the details in the Ninth Circuit opinion that was issued earlier this week, in the majority opinion, the details are sobering from the point of view of how overwhelmed the Federal Protective Service is and what they're facing in Portland. The argument in Chicago, by the way, is that we never let things in Chicago get as bad as they are in Portland. We have never had to close the ICE building. It's always been able to maintain operations. The Illinois State Police is on the job. In Portland, they're having real problems with the cooperation of local law enforcement and the capabilities of the Oregon State Police. And then what's happening, therefore, in the case is you've got three views. You see this in the Ninth Circuit opinion this week in the panel, where there's a petition for rehearing en banc right now that's going to be decided maybe this week. But in the panel, the opinion that controlled for the panel, the per curiam opinion, basically says, we resolve this on the facts, and it's narrowly limited to what they need to do basically to keep ICE open, to keep the federal agency in business, and that is allowed by statute. This is not a presidential arrogation of power as purely as an Article II power. They're actually using a delegation from Congress, and they're using the per curiam opinion uses the narrowest delegation, which is can they execute the laws. And there are a number of precedents for calling out the guard or militia if the laws can't be executed. So then a opinion further to the right is the concurring opinion in the Ninth Circuit that says you don't even have the right to review this. The president gets to make this call unless the Supreme Court overrules a decision that it made in 1827. This is kind of the gray mule decision. Go into that more if you're really interested. So, and then the third opinion is a violent dissent from another judge on the Ninth Circuit that says, this is, you shouldn't let this happen for any of these reasons. You can see the polarization at work when you read the opinions in that case. By the way, I think probably the Portland case is going to stick, and as long as they are making such a narrow request for only that many troops for that narrow a function, my guess is that's going to stick. And the issue that's going to come up before Justice Barrett is going to be in the Chicago case. And the Chicago case has better facts for Chicago and the state of Illinois, and not as good facts for the government. But then the question will be, do you decide it on the facts at all? Is it even reviewable? And Justice Barrett is going to have to make a preliminary call on that question. Yes?
Hi, thank you very much for that really lucid explanation about the trade issues. I'm Alan Weiner. I teach international law here. I'm more of a law of war expert. Our international trade expert is sitting there in the front row. But I did want to return to the trade issues, and I'm wondering if you could help us understand a little bit. It seems to me what I learned from Al Sykes is that the government's strongest argument on the tariffs is that if you have the ability to exclude trade completely, as I think is pretty clear under IEPA, that the power of the whole includes the power of the lesser to impose a tariff on it, and what you think about that argument. And then the other argument that I haven't heard too much about, I mean, there's this incredibly vast array of other trade statutes. I don't really hear people kind of talking about the Jackson kind of covered the field theory, that if Congress had wanted to confer this authority on the president, given how much regulation is done in this area, it would have done so. And the failure, you don't even need an express refusal to confer that authority, but simply the absence of a grant of authority when Congress has covered the field. I haven't heard too much about that argument. Is that in the briefs?
It sure is. Okay. You would be very pleased. We hit that super hard. Actually, you'll see it even in this essay I handed out. It's like there's this overwhelming body of trade law that if you know the trade law. By the way, in the circuit court, there were 11 judges in the en banc circuit court on this. None of the 4 dissenters were trade lawyers in the court in the federal circuit, and if you know the trade law here, that point comes out so strong. There is such an enormous body of law how Congress, and you're absolutely right, and the briefs do hit that hard. The briefs also do tag this kind of the greater does not include the lesser. Because actually it's like, gee, if I have the power to regulate something, I guess I always have the power to tax. Like if you ran that argument, the president would have taxing power in so many places. There are so many subjects on which I can regulate telecommunications. I guess I can tax it too. And then, wow, this president, all that revenue collection stuff that people thought you'd leave to Congress, the president can just handle. So it turns out, and so we make that argument explicitly, by the way. It's like we explicitly say this greater includes the lesser argument is bunk, and here's why, bum, bum, bum. So, yes, the power to regulate something does not confer the power to tax American citizens, which is what you're doing here. I can keep you Frenchmen from bringing your bad wine to our country, but that doesn't give me the power to tax Americans who want to drink it.
Thank you. I'm Vishnu. I'm a 2L here. I guess my question is about the last point you ended your remarks on the foreign terrorist designations. As I understood those statutes, they confer the power to freeze assets. They confer the power for the president to exercise certain immigration powers, deportation of members of those organizations. But they don't on their own authorize or make individuals associated with those organizations lawful targets of lethal action. Maybe I'm wrong about that, and so if you could correct that, that'd be great. But then second, if that's true, and if there's no contest that these groups are not covered by the 2001 or 2 AUMFs, what's the theory of Article 2 power that, and emergency powers generally, that makes the strikes lawful?
It's a good question. First of all, the IEPA, it is true if you are a member of a foreign terrorist organization, it makes you liable for deportation. That's in a different law. So then the question is, if we were at war with these foreign terrorist organizations that are not in the AUMF, so what he's done is he's basically said, I'm dealing with a foreign terrorist organization, and I don't have congressional authorization yet, but I'm doing some episodic strikes, as we did in August 1998, for example, without prior congressional authorization against the al-Qaeda training camps in Afghanistan. He does not have the authority to do that in the United States, at least not yet. He has not yet asserted that authority to simply. Now, there's an argument about insurrection, rebellion that some of the people in the administration are making, but that hasn't yet caught fire in the courts. But on the narco-terrorism thing, if you're outside the country and you're at war with this organization, you're now in this gray area that we've left in our war powers of discrete episodic military actions that are not yet authorized by Congress, for which, and there are precedents for those. This is an uncomfortable gray area of the law. For sure, if Congress would affirmatively assert itself and say no, it has strong Article 1 authority to do that and have that binding, aside from its ability to cut off funds for such military operations, which it has exercised in certain cases. But in this case, Congress doesn't want to go on the record doing that. And so the president's got some space in which to operate for now. But it's a definite gray zone because, see, even in the terrorist case, there were precedents for treating that as an armed attack on Americans, that those groups were actually conspiring to and killing Americans. And so the self-defense arguments played better than they play in a traditional law enforcement context. And this is a source of real tension. And so it's not certain that the orders to attack these boats are legal orders. When I was trying to explain that, I did want you to see that this is a really hard problem because it's the comfortable position is to dismiss this and not notice how hard a problem this is. But I want to go back and take the other side of this, that there is a danger these are unlawful orders. There is also some issues that are going on the legal side of covert action world that are not visible publicly to us yet. But as someone who's spent time in that world, I can see stuff that's going on. Like, for example, when the Trump lawyer who's appointed as the deputy director of the CIA says, you know what, I'm also going to be the general counsel of the CIA too, and I'm going to become the CIA's lawyer, which means that, and the CIA's lawyer plays a crucial role in all these covert action stuff, issues that go on inside the executive branch. That, to an outsider like me, that's a tell. Like, okay, some really, when the head of the Southern Command suddenly retires, that, something's going on. He's raising questions that people don't want raised because they're just right at the edge of things. they're very uncomfortable with. I mean, there could have been an issue. You'll notice recently we attacked this submersible coming out of Colombia, and we fished a couple of people out of the water and treated them. There could have been an issue. I think there probably was an issue. Do we fish them out of the water and take them into custody? And there may have been kind of like, no, just let them drown. And the admiral may have given an order saying, you know what? No, we won't. We have stuff in the vicinity. We're not going to stand by and let them drown. We're going to fish them out. Fishing them out then created an awkward problem for us. What do we do with them now that they're in our custody? And what we did is we very quickly just kicked them back to their countries of origin and said, we hope you'll do something about these people. In one of the cases, Ecuador promptly said, you better believe we won't. And, but we did not want to bring those people back to the United States, where then all sorts of interesting litigation could have ensued. See, right now, none of this is being litigated because there are no good complainants and no good courts of jurisdiction yet. And by fishing those people out of the water, you are creating a possible court venue that could have been really uncomfortable. And the Trump administration solved that problem as quickly as it could. Just to give you some sense of what I think, some of the things I think are going on. But yeah, it's a very close call, very difficult. Yes. Last question.
Try to make it really quick.
Yep.
I don't believe I've heard any discussion in this presentation about constitutional issues. Do you believe that the tariff case or cases will get resolved strictly based on statute? And related to that, major questions doctrine or non-delegation doctrine, will they play a role?
Oh, see, as soon as you find that the emergency powers doesn't work, this is unconstitutional. The whole thing is unconstitutional. There's no legal basis. So this is an unconstitutional violation of the separation of powers. So it turned into a statutory discussion partly because after that they go off the then that makes all the president's actions unconstitutional. Indeed, because there is no legal basis at all, not only will all the IEEPA tariffs fall, all the people who paid tariffs can now file claims and to get their money back in the tens of billions of dollars with interest under federal law, as if you'd won a ruling in the tax court on the scale of thousands and thousands of claimants for tens of billions of dollars, a bill, by the way, that's growing at hundreds of millions a day with interest. That's a potential liability of the government if this is, because then this would be unconstitutional in that particular case. They may try to substitute some other tariffs using other provisions of trade law, like Section 232 of the 1962 Act, but that may create some other issues down the road. But they'll have trouble. These IEEPA tariffs, these emergency powers tariffs, today constitute the large majority of the tariff revenue coming in. The administration has been openly saying they're relying on this for their fiscal policy too, which then makes it almost doubly unconstitutional, since the allocation of authority in the Constitution is so clear. So yes, in the briefs, we hit major questions doctrine very hard. The answer, by the way, that's given to that so far is that there's a foreign affairs escape hatch to the major questions doctrine, citing a remark that Justice Kavanaugh made in a case, in the hope that that will provide a lifeline. Part of the problem is, this is one of the reasons I wanted to draw out the legal tradition and the fact that right from the start, the framers thought that this allocation of power was an allocation of a foreign affairs power. So the idea that major questions doctrine shouldn't apply to the regulate commerce with foreign nations power assigned to Congress. And then there's a variant of major questions, which is non-delegation and intelligible principle. And we make that argument too in the briefs. I just didn't get into it as much today. But yeah, It's, see, in a way, what the argument will come to is, let's suppose we lose on the statutory issue. We're going to fall back and say, well, even if you think IEPA authorizes some sort of tariffs of some dimension, then you've got a major questions doctrine issue or a non-delegation issue. But I didn't reach those questions in the way I presented this today. Actually, and I think the smart path for the court would also be to not reach those questions and just knock the statutory basis down right out and say that this 1975 Court of Customs and Patent Appeals decision is not good law and probably never was.
Please join me in thanking Professor Zelikow.